Hello, this is Matt on the Moon Lambeau channel. In exactly 1 week from today, the SEC and Ripple will meet in court, and Judge Netburn's going to be there. And I have a feeling, the SEC is going to discover that she's not too happy with them, and you'll see why I say that as we go through this latest Moon Lambeau hot jam. So there was a document filed today by Judge Sarah Netburn, which was shared on Twitter by XRP community member and attorney James K. Filan. He shared this just a few hours or so ago. And there's been a lot of speculation as a result of what was filed here. It's a very short letter. It's what's on your screen right now. This is it. Resulted in a lot of speculation, though, by attorneys within the XRP community. And I'm going to share with you their perspectives, including stuff from attorney Jeremy Hogan, as well as attorney Fred Rispoli, who is the XRP community member and attorney who is famous now for having sued Jay Clayton and Bill Hinman. And after speaking with attorney Deaton, he did end up pulling that lawsuit back for now, but he has indicated that it's going to be moving forward in the future. So, but he stated, look, he thinks that the odds for settlement are increasing, and he explains why. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so here we have the tweet from attorney Filan, who wrote the following. XRP community, SEC versus Ripple, hashtag XRP breaking. Conference scheduled for Tuesday, June 7th, 2022 at 3 p.m. to discuss the SEC's renewed assertion of the attorney-client privilege as to the internal documents related to Hinman's June 14th, 2018 speech. So just a little refresher here, what they're talking about here is the judge in January ruled that all of the emails and associated with the Billy Boy Hinman Ethereum free pass speech and the drafts of the speech, and I think I could be misremembering, it like 68 or something like that. There's a ton of drafts of the speech and went out to a ton of people. Well, she ordered in January that you must share this. This is going to be a consideration in this trial, so Ripple would get access to it. And then the SEC, not being thrilled with this, probably because there's exculpatory evidence in there, I'm speculating, of course, they pushed back against this, and they asked for a reconsideration. In April, we got word that the judge said, no, you still really super duper really have to send this over, okay? You cannot keep this for yourself. And then after that, they really didn't like it. And again, that's why I'm speculating there's got to be something pretty damning for the SEC in there. So they pushed back further. And they said, okay, well, actually, we shouldn't have to send over these Bill Hinman Ethereum free pass emails and the drafts of the speech because of attorney-client privilege. And the first time I heard that, I was like, what? Are you kidding me? It's like, so Bill Hinman, he's just like a client of his coworkers at the SEC. It's just the most absurd claim. It's a completely ridiculous claim here. And I think the judge knows that. But anyway, so we're waiting to hear on that. This is undoubtedly going to come up when they meet 1 week from today. And so here's what attorney Jeremy Hogan had to say. He said, nothing like a good old-fashioned in-person hearing to get the blood moving. June 7th, game on. And then somebody named James asked Mr. Hogan the following. He said, Mr. H, what do you think this is all about? And attorney Hogan said the following. I thought through some possibilities, but the most obvious is the SEC's argument on what Hinman's speech was. Personal opinion, division guidance, SEC position, question mark. It's so unbelievably squirrely that she wants to try and lock the SEC down on what their argument is, for the record. And then he also wrote the following. In a separate tweet, he said, I think the judge read the SEC's final brief and found it so incredible, shall we say, that she decided to bring them in person to explain the argument and create a clear record since she knows she's being appealed on her decision. Yeah, exactly. So here's what I think is going to happen. Regarding this bogus attorney-client privilege stuff, the SEC is going to get smacked down on that. The SEC then isn't going to be happy, and there will be an appeal to Judge Torres. I fully anticipate that's going to happen based on the opinions that I've seen from attorneys within the XRP community. And then once Torres smacks down the SEC again, which seems inevitable, they can go to another court that's a higher level up. And then they can push further if they want to, which they might. Maybe they wouldn't, but there has to be something that is just like case ending for the SEC, or else why do you push this hard on this one thing? They're not fighting this hard on any other aspect of the case, period. So there has to be something critically damaging in these emails and or the drafts of the Bill Hinman free pass speech. Or what's the purpose of all this? And it's also silly that the final attempt here, making this bogus claim about attorney-client privilege, if that's the case, why didn't you start with that? If you actually believe that this is an attorney-client privilege situation, you lead with that, because that's that should be pretty ironclad, don't you think? But they didn't. It's like they went through all these other motions and considerations and final decisions from Judge Knepper, went through all this, which really was completely unnecessary because there's actually attorney-client privilege. It's just the most absurd thing on the damn planet. Now, here's what attorney Fred Rispoli had to say about this, and I found his take to be rather fascinating. Check this out. He said, "My thoughts on this unusual hearing setting. First, an in-person hearing allows certain privacy. In courtroom will be on the record, but Judge Netburn can also take attorneys back to her office in chambers for off-the-record discussions. Nothing prevents her from ruling without a hearing, so why order one? My gut tells me she wants to politely rake SEC over the coals for such a bleep show of emotion practice on this issue. Force SEC to take positions it cannot waffle on later. In chambers, she could also alert Ripple in front of SEC that emails are terrible for SEC. She could also let SEC know that Judge Torres is highly unlikely to overturn Netburn's decision. The danger option for Ripple is if Netburn allows SEC a do-over, in the sense that she forces it to choose once and for all whether Hinman's speech was personal or on behalf of the SEC." And then parentheses he writes, "as it has quasi-argued at various points," into parentheses. Yeah, they've been speaking out of both sides of their mouth. It's fair to say. Yeah, just his personal opinion. Well, but it's the division's opinion, the division he's running, the division of corporation finance. Oh, okay, gotcha. It's both, okay. And then Fred writes, "This is unlikely, in my opinion, but would give SEC a chance to save face while simultaneously pushing the dagger further into the SEC on fair notice defense, and it's already pretty deep up there." And then he was asked by Mickle XRP, "Do you think this increases the chance of a settlement?" Excellent question. Well, here's what attorney Rispoli had to say. "Of 4 exits to ending this lawsuit, in my opinion, number 1 is forcing SEC to turn over emails. Unless Netburn really has that come to the Lord discussion with the SEC, I think it continues its will win in the end mentality and moves on to Torres after losing here. But yes, settlement odds increasing." Ooh. Which is still completely what I anticipate. Unless something bizarre happened and the SEC was no longer required to hand over these Bill Hinman emails, fine. Something like that happens, fine. But outside of something like that, they're not handing those emails. I don't think they're ever going to hand those emails over. They will settle before handing them over. So to me, that just makes the most sense here. And then Fred Rispoli also wrote the following. "All the lawyers and non-lawyers clearly saw the ridiculousness the SEC went through on this one issue that I just think Netburn decided SEC needs a talking to. But unless she really unloads on the SEC, I don't see SEC settling until losing before Judge Torres on the email issue." So on that aspect, it seems like Attorney Hogan and Attorney Rispoli kind of had the same gut feeling about this, which is that the SEC making this absurd attorney-client privilege claim is ridiculous, and she's like, okay, we're meeting in person. Needs a stern talking to at this point. And it is that ridiculous. I've covered it in great detail. The arguments from the SEC and Ripple's response to this bogus claim, it is one of the most absurd things in this entire case, and there's been a lot of absurdity from the asshats at the SEC. That's for damn sure. And then somebody named Jack wrote to Attorney Rispoli and said, "The problem with the SEC taking on Ethereum as not a security opens the door as to how and why they came to this conclusion. Either scenario is a win for Ripple, in my opinion." And Attorney Rispoli seems to agree, and he wrote, "Yes, great takeaway. SEC saves face with Hinman and maybe keep emails hidden, but by assuming responsibility for the speech, there is a 0% chance it can defeat fair notice defense, which is why SEC did not argue speech was government sanctioned initially, but never predicted having its internal house exposed. Exactly. So look, again, I don't anticipate it's likely that these emails are going to be allowed to be held back. So, and why might that happen? Well, I mean, if it were actually an official decree from the SEC, okay, fine. But as Attorney Rispoli points out, if that were to be the case, okay, disappointing, emails no longer have to be shared with Ripple, and we'll never know what's in them then. But if that happens, how the hell can the SEC win? As he cites here, Ripple's fair notice defense, that'd be a slam dunk at that point, because if that speech is official government decree from the SEC, well, apply XRP to those standards, and you can see that XRP fits that test that Hinman set out better than Ethereum does. There wasn't even an ICO. So either way, I mean, there's just any way you look at this, this is not looking pretty for the SEC. It really isn't, and it is a pleasure to be able to report that. That's where we're at, folks. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.